Hey everybody, John Skiba here, and welcome to Thursday night. I'm doing things a little bit earlier tonight because I've got places to be. So we're starting about 15 minutes early, so I hope that's okay with everybody. But each and every Thursday night, I'm here answering questions, having discussions about all things debt related, whether it be bankruptcy, wage garnishments, debt collection lawsuits, particularly those against our arch enemy here, the junk debt buyers. And so my normal disclaimer is this, that, hey, I appreciate questions. I like to put them up on the screen here. We can discuss it. While I am a licensed attorney in the state of Arizona, nothing here should be construed as legal advice because we likely have not met, and I don't know the facts of your particular situation. So it also doesn't create any type of attorney-client relationship. A lot of times I get emails from people after these live streams. Unfortunately, I can't respond to those with any type of specific legal advice. So, but I appreciate it. You here again. If you have a question, go ahead and put it over there in the chat section. We'll put it up on the screen and we'll talk about it. I wanted to kick off tonight, actually kind of touching base on a video that I just put up earlier this week about what people are kind of debating between bankruptcy and a non-bankruptcy option like Dave Ramsey. A lot of people are surprised to learn that I'm actually certified through Dave Ramsey's organization as one of his master financial coaches. I don't work for him, but you can go to his organization and get certified, which I have done. And I did that because there are situations where bankruptcy is just not a good idea. And I wanted to have something else to be able to provide to my clients when bankruptcy didn't work. And so I shared that video. You might want to go check that video out. I talk a little bit about why I think that, why I think Dave Ramsey is so against bankruptcy. I tell you about some kind of cool experiences I've had. I've actually been to Dave Ramsey's house. I've sat in his kitchen, had dinner with him, and be able to hear from him directly as far as what his approach to getting rid of debt is and his thoughts on bankruptcy. So that may be something that you might find interesting. Go ahead and check that out as far as some of my thoughts on bankruptcy. All right, let's jump into some questions. I see Laura, who's one of the biggest supporters of the channel. I appreciate that. A question about stipulated judgments. Is this something turned into the court and recorded as or just a document between the parties? So, Laura, this is a great question. So, a stipulated judgment, and I'll back up just a bit to give some context. If there's been a lawsuit that's been filed and you're trying to negotiate a settlement of sorts, particularly if what you're trying to offer is not a lump sum settlement. So let's say that there's $10,000 that the creditor is suing for, and you want to try to settle this, but you don't have, $4,000, $5,000, $6,000 to just dump in one lump sum settlement. You're looking for more of a long-term payment. You can offer a proposal, even if it's on a lower amount. So you can say, hey, I'll pay you $6,000, but I can only pay $250 a month. The creditor may take that, but the issue that they're running into is procedural. The courts are not going to keep this thing open for 2 years while you make your monthly payments. They're not going to do that. And so the creditor doesn't want to just agree to a payment, and then you get 6 months into this payment plan and then tell them to pound sand, and then you're not. They're in a situation where now they have to either refile the lawsuit, or even in a worst case scenario, maybe the statute of limitations is now run. And so they're going to want some kind of security, some type of insurance policy that you're going to make the payments. So you can propose to them entering into a stipulated judgment. A stipulated judgment is where both sides agree, they sign off on it, where you usually agree to a judgment in the full balance that they're seeking, but then there's a term in there that says, but we're also settling this now for the lesser amount. Here's how much is going to be paid each month, and then it's paid out over time. There's also a very important term that's included in a stipulated judgment. It's called a covenant not to execute, or a covenant not to collect, meaning that they're not going to, as long as you're making the payments like the agreement is, they're not going to garnish your wages or go out and hit your bank account, anything like that. So in most instances, at least in my experience, Laura, the stipulated judgment is actually filed at the court. And the reason it's filed at the court is because, like I said, the courts have the rules of civil procedure. They're designed to keep cases moving so that somebody can't just file a lawsuit and then it just sits there for the next 5 years. Because eventually, if nothing happens, they'll dismiss. So the stipulated judgment is usually filed with the court. The court will then essentially enter judgment, close it out, and then once you complete your settlement, once the payment arrangement is done, they will file something called a satisfaction of judgment. Like in Arizona specifically, it's actually by law they're required to file that satisfaction of judgment, and so they'll submit that. So yes, the answer is that there will be a court. It will be filed with the court. So L. Anderson's asking if it's buffering. I hope not. We've had some internet issues here in Mesa, Arizona. We've had rainstorms that have been horrible and threw out some of the Cox Communications connection to our building. So if anybody else is having problems, let me know. Hopefully it's not buffering so bad that you're not even able to hear it. I'm not hearing anything else. So, and that may be a bad sign as well. So Laura, I hope that answers your question related to stipulated judgments. I find that these are most effective when you're dealing with an original creditor. If you've been sued by American Express, by Capital One, somebody like that, or if it's like a repossession on a car, if there's like a deficiency balance, that can be an issue. So I hope that helps out. I wonder if we are having internet problems. Usually we have a few more questions than that. Because I'm fine if we end early right now. Oh, there's one more. All right, Mary. Okay, Laura, we got the thumbs up from Laura. Good. Apparently Laura can hear. Hopefully it's not buffering or we're not having any other issues here. We do have a question here from Mary. How long do you have to mail your response? Mary, if you could provide me a little bit more context, I'm assuming you're talking about your answer to the complaint. That will depend. So if you get served a copy of the complaint and the summons, look in the summons and see how much time you have to respond. Most jurisdictions are going to be somewhere between 20 to 30 days. And so you're going to want to look at that date and make sure that you hit it. There's not generally any kind of grace period or anything like that. So you need to look on that summons specifically and determine how much longer you have to be able to submit that with, and if you can even do it by mail. You may want to contact the clerk of the court. Courts are all over the place. Even in Arizona, different courts have different ways of accepting things. Superior Court here requires things to be electronically filed. The justice courts are generally either mail or in person, but during COVID-19, they've been allowing email filing. So, but not all courts are that way. So that may be something that you want to check out. So, all right. I think we may keep it short tonight then. Hopefully I haven't had buffering problems. Appreciate all of those who check in each and every week. If there are topics that would be helpful for me to do videos on, I would always appreciate you. Throw them in the comments to this video. And I do read all the comments. So if you have a topic that is specific to something you want to hear about in the future, I do 2 videos a week. And so I'm always thinking of things that we need to talk about. I think it would be awesome if you could put those in here. All right, let's see if we got Mary. Yes, the one that went to the court. Yes, that was what it is. I went to the court and I found I need to send the attorney a copy. Okay, so you need to make sure you file the answer timely within that 20, 30 days, whatever it is in your state. And then you do have to mail a copy to the other attorney. In most jurisdictions, the court's not going to do that for you. You need to mail it. So you're supposed to, usually on the last page, is what we call a mailing certificate, where you state the date that you mailed it. So you need to make sure you mail it on that day and send it out. So I usually say, just plan on doing it, get a timestamp, send a copy over to the other side. All right, let's see. Mitch says, once I answer the court as to the lawsuit filed, should I go to mediation before hiring a lawyer? I have done once with Calvary, settled for 25. I hope that's 25 bucks, because that would be sweet. Maybe 25 cents. But I'm biased on this. I can give you my perspective as a lawyer. I prefer to get involved early on. I prefer to be the one who drafts the answer and files the answer. If I'm going to litigate the case, I kind of want to have control of it from the very beginning. But I realize that particularly some attorneys, the way they do their billing, that may make it more expensive. So an attorney can get involved at any time. I guess the question is whether the attorneys are going to be willing to at a later date, depending on everything that's played ahead. So So I would, that's up to you, but yes, I mean, the answer is that you can get the attorney involved. Sometimes if you go to mediation, the case will settle, and then you don't have the added expense of an attorney, but there's no specific time frame when an attorney needs to be involved. They will just, it's really more the attorney when the attorney's willing to do it. So, all right. Can you seal the documents to a bankruptcy? When I inquire, attorneys give me a hard time. It's probably something you'd want to reach out to the clerk of the court at the bankruptcy court and see if they can do it. Technically, documents on the court's record are public, and by public, it's not like they're posting a list of people who file for bankruptcy on the outside of the court. Someone would have to go into the clerk of the court, and they would have to ask for your information specifically. And even then, the clerk may not just hand it all over. They may have them fill out a form or something. But it is something where if there's particularly sensitive information in there, you can file a request to have the court seal it. So it's probably not really an attorney thing. It's more of a court thing. And there are only specific instances where the court will do it. Because they are public records, there's got to be something in there like names of minors, non-filing people, social security numbers, that kind of thing. All right. Marcos, okay, you weren't kidding on sleep when you said that we were on the judge's timeline. It's their world. We just all work in it and live in it. That's the truth. Thank you, Marcos, for supporting. And appreciate Dave Lamb for showing up. Gosh, I about cut this thing off early before Dave and Marcos got here. That would have been horrible. All right, let's talk about this one here from Ike. Hi, John. What is required for a bill of sale to be considered evidence of a proper chain of custody? If it shows a bulk purchase and not my specific account in the bill of sale, is that proof? Well, if you talk to a debt buyer attorney, they're going to say that's proof because that's usually all they have. So this really gets into it when we're talking about junk debt buyer cases. So let's say we have portfolio recovery associates. They're claiming they bought a Citibank account. They're going to have a bill of sale. Sometimes it's called a bill of sale and assignment. And it's going to be very generic. It's going to be like 1 or 2 paragraphs stating, hey, Citibank sold unknown counts pursuant to some master purchase and sale agreement of the accounts listed as Exhibit A or Schedule 1 or something like that. And when you actually look at that, there either is no schedule or they have what they're calling an extraction from that. You don't get the actual document. So that should not be enough. The bill of sale in and of itself should not be enough for them to establish that your account has been transferred. They've got to show your account is. Sometimes I'll object in a trial type setting to a bill of sale that doesn't have anything that has my client's name, their account number on it. I'll object to relevance because why is this even relevant to these proceedings? It's not tied in any way to the defendant in the case. And so it shouldn't be enough. Some judges will allow it. But again, there shouldn't be a whole lot of weight there if it doesn't have the specific information in there as to your particular account. Tiffany, thank you for supporting the channel. I sincerely appreciate it. Thank you. All right, let's do a couple others here. Frankie, I paid a collection in court January 2020. It was never updated after I sent the certified mail receipt to all of the CBs. Okay, I know that's going to come to me in a minute, what that stands for. Second collection, portfolio recovery is now taking me to court on the same account that I paid. Well, I can tell you this. If you settle an account and it's documented, they said they would take payment for settlement. You have something in writing proving it. You prove that you paid it. It was never updated. Credit bureaus. That's it. Thanks, Frankie. Thank you. Got it. In the Fair Credit Reporting Act, they refer to the credit bureaus as a CRA, a credit reporting agency. And so sometimes I don't, there's too many acronyms in law, period. But let me tell you this, Frankie. So the thing that is, you should be so lucky if your facts are what I'm saying they are, because you're going to have a good case to file a lawsuit against them. If you're in Arizona, you need to call me because we'll sue these guys. If you settle the debt and you have documented proof that they settled it, and it's done, and then they transferred it to portfolio recovery, and they're suing you on the same debt that was already settled, and if it's not updated on your credit report, and if it happened less than a year ago, because there's a 1-year statute of limitations on the Fair Debt Collection Practices Act. If all of that comes into play, you have a great FDCPA case. Now, obviously, I haven't seen all the facts. I'm just telling you what ifs, that there are some things there that could help you. So I think that that's what you need to look at here, is if it was settled, paid, and then they're filing a second suit, you have a great FDCPA case, and that will be awesome. So because the issue is, and we see this all the time, I can tell you a lot of times when settlements happen and you look at the credit report, they don't update it. That's a violation as well that you can deal with. So, all right, Ike, thanks. Ike, I think that's the biggest. I don't even know exactly what they're called. Some kind of supers that YouTube does that anybody's ever done on here. Thank you very much. I appreciate you supporting that. And I do have to bail a little early tonight, so I apologize about that. I've got a commitment I've got to get to. I appreciate everybody working with me. I started a little bit early, but we still got a good group in here tonight. I was leaving off there. If there are topics that you would want to hear from specifically, put them in this the chat here. I do take a look at those. I'll start making some videos on request on some, whatever specific you want to talk about. I'm happy to address those things and help you as you're battling these different debt buyers and everything else that goes along with it. Look at Frankie. Frankie's one up in here. Frankie, you did it. You are now the champion. I appreciate y'all, and I hope you have a good night.